have a couple more people join us throughout the conversation, so that's great. And as Alenia referred, we are going to be recording the conversation, just so you know. So my name is Monica Villegas-Patan. I'm the Executive Director. I think I know most of you, but just in case, the Executive Director at Legal Services of Greater Miami. If you're joining tonight, I'm guessing you know who we are and what we do, but I'll give you the 10-second recap just in case. Legal Services of Greater Miami, we're a civil legal aid organization that serves both Miami-Dade and Monroe County. We've been around for 50 plus years, so I hate it when I hear that we're the best kept secret ever. We have, I also get the question if we actually have attorneys and staff or if we're just pro bono. Sorry, Jamie, not just pro, but only pro bono. So we actually have a staff of about 30 attorneys and support staff. We're about 60 employees total serving the community. And then Jamie Cassidy, who's on the conversation today, and I'm sure most of you, if you don't, you've probably got an email from her. This is the face that goes with that email. She reaches out. She's our pro bono advocacy director. She heads up our pro bono efforts. So ensuring that whatever our attorneys can't cover, sort of leveraging the generosity and expertise of the private bar to meet our clients' needs. So thank you for those of you that engage with us in that way. And if you don't, maybe you'll think about it after today. I want to welcome everybody. This Conversations with Leaders, it's our inaugural one. It is hosted by our Young Professionals Council. And we are really excited to be doing this, and especially with Raoul Cantero as our inaugural leader that we'll be speaking with. I'm going to let Jenny introduce him, but I'm going to have the pleasure of introducing Jenny Fine. She's the chair of our Young Professionals Council. She's been involved with the organization even before she went to law school, actually. She was a clerk with us, so that was great. But now she's on to, I'll say different things. I was going to say bigger and better, but different things, probably better in some instances. She's an attorney at Bilzen, and she still gives generously of her time with us through her Young Professionals Council activities and really gearing everybody up to do either support us financially or engage on pro bono. So with that, I'll hand it over to Jenny. I also maybe want to point out before I do that, we do have a lot of the leadership from legal services here, and in case some of you run into them or know them, we have Vivian Chavez. She's our Deputy Director of Operations. Jeffrey Hearn, which I'm sure you all know or have heard of, our Director of Litigation. We have Alenia Sanchez-Bryson. She's our Chief Information Officer. We're one of the only legal aids in the state to have that. She's an attorney, and she's figured out how we can actually use technology in a productive way in the practice of law for our organization and our low-income clients, so that's great. And I already introduced Jamie Cassidy, our Pro Bono Advocacy Director. So I don't think I missed anybody. If I missed somebody from Legal Services, I apologize. But I'll hand it over to Jenny now. Thank you so much.
Thanks so much, Monica. I'm so happy to be here with everyone, and I'm so excited for tonight's conversation. I'm going to give a quick intro to our, speaker for tonight as our featured leader. Raoul Cantero of White & Case LLP is a former Florida Supreme Court Justice with an outstanding presence in the appellate field, offering clients market-leading abilities in their most challenging litigation matters. Clients say Raoul's greatest strengths are his ability to analyze, distill, and argue complex issues in a simple, understandable way. Justice Cantero is also the firm's office executive partner in Miami, leading a contingent of 95 lawyers and over 100 support staff. From 2014 to 2019, he was global executive partner for diversity, in which position he oversaw the firm's recruitment, retention, and promotion of minority lawyers. In 2016, Law 360 found that White & Case was the most diverse law firm in the U.S., with over a third of its attorneys being minorities. In addition, AmLaw has ranked White & Case #1 in the diversity of attorneys for 4 consecutive years. Appointed to the Florida Supreme Court in 2002 by then Governor Jeb Bush, Mr. Cantero was the first justice of Hispanic descent and one of the youngest ever to sit on the court. In his 6 years as a justice, he heard hundreds of appeals and authored well over 100 opinions. So thank you so much for being here with us tonight. We really appreciate your time. And I think that where I ended the intro is a good place to start. Maybe tell us about, well, I guess we'll go a little bit before that. Can you tell us a little bit about your legal career before being appointed to the Florida Supreme Court?
Sure. First, I want to say hello to everybody and welcome to everybody who's on here. It's really an honor for me to be the inaugural host for this event. I think it's going to be a great series, and I'm glad that Legal Services is doing it. And I'm a little intimidated because I see so many people on here that are great leaders themselves that are tuning in, like Bob Josephsberg, who is really a giant of the legal community in Miami. So I'm flattered that so many people are tuning in, and I really appreciate the work that Legal Services is doing.
Your Honor, the reason I'm in here is because I learned 30 years ago that whenever I could hear you speak, I would enjoy it and I would learn something. And I'll never stop doing that. That's why I'm on here.
I really appreciate that. That's an honor. It's very flattering. So what I did before I joined the court, first I clerked for Judge Edward B. Davis in the Southern District of Florida, a great man himself, and he really was the reason that I wanted to become a judge, because I saw how humble he was, how great of a person he was, how he didn't let it get to his head that he was a judge, and he kept a sense of humor even in the courtroom with the attorneys. Added a sense of levity to the proceedings, and was great with his law clerks. I remember him taking me to Miami Dolphins games during my clerkship. So I learned a lot from that. Then I spent a year in Panama on a Fulbright scholarship there, doing something totally non-legal, writing fiction and writing short stories and learning Latin American history and literature. So that was a great year. Also the year where the whole Noriega fiasco began, before the invasion of Panama, when all the demonstrations began. So I call it the year of living dangerously, after the movie by the same name. It was a lot of fun. Then I kind of decided not to go to a big firm, despite the fact that I'm at a big firm. And I went to a very small, kind of a startup firm at the time. It was only about a year, 18 months old. I knew Hank Adorno from his days at a boutique litigation firm called Paul and Thompson, where I had clerked in 1982, and then in Thompson Zeter, and he set up a firm himself and enticed me to go over there. So I was only the 13th attorney there. And I kind of went on a whim, and it ended up, by the time I left 14 years later, we were 150 attorneys. I had a writing background, so I liked to write. The attorneys there, most of the partners were former state prosecutors. And so if you know anything about prosecutors, maybe Bob can tell you, they love to stand up in court and argue in the courtroom. But a lot of them don't like to sit down and write a lot and write briefs. To them, that's anathema. And so it was like, when appeals came, it said, give it to Mikey, he'll like it. And they would hand me the appeals. So even as a young associate, I found myself doing a lot of appeals. And then as the firm grew, as our litigation departments grew, we had a zoning department, we had a commercial litigation department, we had an insurance defense department, we had a criminal defense department. So I ended up doing all kinds of appeals from all of those partners, and they would just feed me all of their appeals. And so I was able to get a lot of experience that people usually don't get in a firm setting. They usually get it in a public sector setting. So I was very fortunate. By the time I applied to become a justice of the Florida Supreme Court, I had done over 250 appeals and had handled over 100 oral arguments, just because of all the appeals that were generated internally.
Wow. Well, that kind of leads us in, I guess, to our next question. You kind of started giving us the answer about, your road to becoming a judge. So you had all this great experience. I don't know if you want to tell us a little bit more about your path, and then also just we were wondering, how has being a judge impacted, kind of your personal life and the rest of your career?
Well, as I had said, the seeds of wanting to become a judge really were planted when I clerked for Judge Davis. And I really liked the fact that as the judge, you were objective, you were neutral. Your job was to determine, to get to the truth, to get to what the results should be, not advocating for any particular result, but trying to do the right thing. And I really enjoyed that. And sometimes it was difficult because it was close calls, but it was very exciting to just try to reach the right result in cases. And Judge Davis was very amenable to discussing, what the law was, how a particular case should be decided. He gave me a lot of leeway in the drafting process. So that's really what got me started. And then, the fact that I really loved to write, and I loved what I was doing in the appellate process. I thought, one day I would want to be an appellate judge. Frankly, I never dreamed of being a Supreme Court justice. Right up until the time I applied, I never dreamed of doing it. What I was thinking of doing is becoming a third DCA judge one day. And that's really what I wanted to start doing. At some point early in my career, I developed that feeling that one day I would want to do that. And one thing I would advise everybody that's tuning in is that regardless of whether you ever want to be a judge, I would download the application for the JNC process, because that really gives you an idea of what a lawyer should be, regardless of whether you eventually aspire to be a judge, because they ask you a lot of questions there that really, if you're able to answer them correctly, that means that you've done a good job as a lawyer. They're going to ask you what kind of things you do in the community besides law. What activities do you have? What nonprofit activities are you involved in? What leadership in the community have you been involved in? What are the opposing counsel in your last 5 cases, the name and number of your opposing counsel? Let me tell you, if you've ever made any enemies, they're going to come out of the closet at this point, and people are going to know about it. I was very fortunate and honored that a lot of my opposing counsel wrote letters in my favor. And that's because I always had the attitude that even though we were in litigation, just because our clients were enemies doesn't mean that their attorneys had to become enemies as well. In fact, it always facilitated the process if their attorneys got along and acted professionally toward one another. So I always tried to act professionally and exude that. And believe me, if at any time you don't act professionally, that's going to come back to bite you when you apply. So download that application, and it gives you kind of a step-by-step approach of how to go about being a lawyer and how you're going to have your career go, and the steps you need to take.
That's definitely great advice. I think we're all going to probably download that application as soon as we get off of this call tonight and think long and hard about what we would answer, and how other people would answer when asked. So thank you for that advice. We wanted to kind of talk about also your experience working in private practice, and after, your time on the bench, how has the practice of law changed in the past few decades, specifically, the business of the practice of law, and especially in your kind of leadership positions at the firm? What kind of insight, can you give us about the changes?
Well, I think there have been some really cataclysmic and important changes in the practice since I've been practicing, and certainly since I've returned. I mean, there have been cataclysmic changes just in the past 9 months. And the way we practice law and the way we argue in court, I mean, those are pretty important changes. But even before then, I can tell you, when I was an associate, the concern that partners had for associates' well-being was at a much lower level then than it is now. And I think, frankly, it's an improvement. I noticed when, I can tell you a couple of stories. When I was an associate, um, a partner called me into his office one day and said, "Hey, Raul, we'd like to see you around the office a little bit more on Saturdays." I said, "Saturdays?" He said, "Yeah, we see you around the office here, but on Saturdays, we never see you around." And I said, "Well, let me ask you something. Is there a problem with the amount of my hours?" No, your hours are great. You're over 2,000 a year, you're fine. I said, is there a problem with the quality of my work? No, there's no problem with that. We love your work. I said, well, then why should it matter when and where I'm getting that work done? Just because I'm not here on a Saturday doesn't mean I'm not working on Saturdays, but it means that I have children and I want to spend some quality time with them. So why should it matter where I'm working from on a Saturday if I'm getting the work done? And the good news, I didn't get fired. And from then on, they never asked me any more questions about it. But that was kind of, that's an example of nowadays, even before COVID and people have to work remotely. I think since I've come back to practice, at least at my firm and a lot of firms I know of, I think the partnership is a lot more cognizant of the work-life balance for associates and much more concerned about that. I don't think that we necessarily coddle the associates, but before, when I was at my prior firm, and I know there's a lot of war stories about this. You had a lot of partners that would give arbitrary deadlines. They need this by tomorrow morning just because they were spoiled and they wanted something by tomorrow morning. Or they just wanted to have an associate work over the weekend. I think now, I warn associates in the practice, this is the life we have chosen. So we've chosen to be lawyers, and especially in litigation, it's like choosing to be a doctor. It's not necessarily a 9-to-5 job, but to the extent that we have deadlines when we're working under a rush, I want to make sure, and I think our partners make sure, that it's because of a court deadline or a client deadline, and not because it's an artificial deadline. And so there are certain deadlines that we can't avoid because it's the nature of what we do, but there's other ones that we can avoid. So the extent we can avoid them, I think we should. Another explosion in change is the technology. We're very blessed as a profession that we can work remotely and that it hasn't really hurt, at least a lot of types of legal practice. Some types it has, but the commercial litigation, the only thing that's really hurt is actually going to trial. But other than that, we're still working on all cylinders. And if it weren't for technology, we wouldn't be able to do that. I don't know what we would do if we weren't able to have remote hearings. I guess maybe we'd be doing it by phone. God forbid. Can you imagine that? So the technology has exploded. That also means that even before COVID, when we want to work remotely, sometimes now you're reachable 24/7. Your clients can text you at any time, email you at any time, and they want you to respond immediately. And if you don't, then they get antsy sometimes. So I think that's also increased the stress on lawyers because of client demands, court demands, orders come in. We've all seen orders come in during the weekend, orders come in at night. So that, I think, decreases the amount of free time that we have, because we always have to think, even if we're on vacation, check our emails, what's going on, has an order come in, there's an emergency motion, things like that. So I think that's increased the stress and the need for attorneys to find a way to de-stress. I think another explosion in change has been the ways that firms use technology to follow their cases and the profitability, not only generally of their practice, but of each individual matter, of each individual attorney. everything is measured now, not just the hours, but the hours you spend on a particular matter, at what billing rate, and the amount of time spent versus the amount paid, and was that particular matter profitable or not during a particular month or period. Everything that we know of now can be measured, and we see all of these financial statistics. I see them as my office's executive partner on a monthly basis for the office as a whole, for the different practice groups, by associate and partner. So it's amazing how things can be measured. And when you can do that, I think there is a danger of being tempted to cut corners in the quality of representation to assure that the profitability goals are met. And so when I'm working on a matter, frankly, I don't even look at what the stats are, because I need to spend as much time doing as much work, getting the quality to the best I can in order to make the best case for my client. And I will determine whether it was profitable or not at the end, but not anywhere before then. But there is that temptation to do that. And, you know, when there's that temptation and you see those numbers, there's some people are going to fall into that that temptation of cutting corners in order to remain profitable. So these are all changes in the profession that have come about, and some are good, some are bad, some are neutral. They're good or bad depending on how you use them.
Yeah, I think we've all seen most, if not all, of those changes, like you said, some for better, some for worse. But, you know, it's interesting to hear from your perspective. So thank you for sharing that. The next thing I wanted to ask you about is, you know, you've published several articles dealing not only with diversity, but also with implicit bias and inclusion. And in 2020, as we all know, this issue has really come to the forefront of both our society and culture and the practice of law. So do you have any suggestions for young professionals to ensure that we're trying to help promote, you know, an inclusive workspace?
Yeah, I think the issue of implicit bias is going to continue to affect everybody, because implicit bias is just a recognition of the human condition. And you don't have to be a white male to have implicit bias, or a white female. Everybody has an implicit bias against any group that that person doesn't belong to, because they don't understand that group, and they make certain assumptions about that group. We've seen it. You know, a perfect example would be a man who sees a woman at the hospital and thinks that woman is a nurse when that woman is a doctor. You know, because men were used to seeing women as nurses, not as doctors. Well, now they're doctors, so you can't make that assumption. But I think there has to be understanding on both sides, knowing that that bias exists, and then reacting against it in a particular case, and also being understanding on the other side, knowing that implicit bias doesn't mean that the person is prejudiced or willfully biased against somebody. It's just human nature, and you have to educate people so that that human nature can be changed and educated. So that's going to be an issue, I think, for years to come. What I think is helping now is the entire concept of implicit bias, that, you know, is only a phrase, a term that we've been hearing in the last, I don't know, 5 or 10 years, if that, where people are starting to recognize, oh yeah, there is that implicit bias. It's okay. It's not a prejudice. It's just something that we all have, and we have to see it and then react against it so it doesn't happen.
Definitely. We also wanted to ask you about your involvement with legal services. You know, we're so grateful that you've been such a staunch supporter of legal services throughout the years, and you're an active member of the campaign committee. You always lend your support to our mission, whether personally or through your firm, White & Case. why do you think it's important, and why, has it been important to you to support legal services for all these years?
Well, as I tell, law students and young lawyers, every lawyer has been educated to become a leader. And because we're privileged in having an education about the legal system, an education that most people don't have, they don't understand, they don't have the capacity or the qualifications to act within that system. And therefore, they don't know about how to change laws, how to achieve justice. But lawyers, by definition, have that ability. So we, by definition, are educated to be leaders, and each of us has to become a leader and give back to the community. And for lawyers, for the general population, of course, there's the United Way. I'm involved in Catholic organizations. There's the Cancer Society. There's so many different organizations that need money and that are very worthwhile to give and to be involved in. But for lawyers, what better organization and what better vocation to get involved in than to help those who don't have lawyers, that can't afford legal services, so that everybody has the opportunity to be represented and to try to achieve justice in their case. So I think of all the different activities that lawyers can have in the community and where they can give. To me, the number one has to be giving to legal services organizations, so that they can make sure that we can achieve justice for even the most indigent. And that includes also giving of time and resources to help legal services organizations like Legal Services of Greater Miami. So, that's why I've been involved. That's why I feel so strongly about it. It's such a natural fit for a lawyer to be involved in that.
Well, thanks so much, Ronner. We really appreciate, your commitment to the organization, all your time, energy, and especially your time tonight. I know when we talked before this that you wanted to give a lot of time for people to ask questions. I know you wanted to hear from, the members of the Young Professionals Council and everyone else who's attended. So I wanted to give us enough time to make sure that we answer any questions that anyone might have. You've had a pretty illustrious career, so I'm sure we have some questions out there. So if anyone wants to unmute yourself, you can go ahead and do so to ask your question, or you can write it in the chat if you have a question that you want to ask. Oh, I see one from Brianna. Do you want to read it? Do you want me to read it out loud? Oh, I see you just sent it to me. Sorry. I'll ask it on behalf of Brianna. Do judges do implicit bias training? She wants to know if that's a silly question, but I think it's not. I think it's a good question, that maybe that's something that wasn't a thing, when you first became a judge, and that now is, or, you can give us kind of more information about what that looks like for judges, what that kind of training looks like for judges.
Yeah, I know that when I became a justice, there was no implicit bias training, and there was none during my entire tenure. So by the time I left in 2008, there still was not implicit bias training. I think now there is. I'm not sure when it started or what the parameters are. I know I'm not going to name names, but I can see that there's at least one judge on this Zoom call. So if that judge wants to identify him or herself and explain to us what kind of training exists, I invite that person to do so. But I know that they do it. Oh, there we go.
Hey, it's Judge Raoul. I'm not going to take
Judge Raoul. No, I wasn't thinking of you.
Oh, okay.
No, I'm kidding. I saw you there.
Oh, okay. Good to see you. There is training. One of the things that we do is you take something called the implicit association test, which if you Google it, Harvard has it on there. And all judges are required to do continuing judicial education. And a part of that is implicit bias training, which pretty much can happen almost on a yearly basis, if not at least every 2 years. And it's a big part of new judge education and even for continuing judges. So.
Thank you, Judge.
Sure.
I have a question, if that's okay.
Hi, Monica.
Hi. So first of all, I realized that when I introduced Jamie Cassidy, I forgot to mention her newest position, which is a follow-up to my question. So Jamie Cassidy no fear, will continue to be the pro bono advocacy director, but she will also, in all her spare time, she's now going to serve as our chief diversity officer for the organization. Over the past few months, we've sort of been looking both internally in terms of our organization and then externally in terms of our advocacy and ensuring that we're sort of keeping ourselves in check, basically, for lack of rather than getting into the whole explanation. But along those same lines, Judge, you were the first in a lot of rooms often, whether it be the first Hispanic and I guess, I looked at the publications, you were writing about diversity and inclusion a while back, and I'm just curious, what are some of the, whether it was formal practices, or I doubt there are policy, but formal practices that a firm had or in the judicial space that made you feel that you felt more included in? Because I think there's diversity and then there's inclusion, and inclusion I think is the gold standard, which we're going for. And so were there any sort of practices, or does your firm have any now that you think are especially successful? I'm just curious, because we're sort of embarking on this journey ourselves.
Well, we do have affinity groups at our firm. We have the Black Affinity Group, Hispanic Affinity Group, and other groups that kind of get together and discuss issues related to their particular group, and also promote and put on programs. For example, we have for Black History Month, we always have a major speaker come in and speak, sometimes across several offices in the US, sometimes locally. Hispanic Heritage Month, we also celebrate things like that. Also, we make sure that if there's particular holidays that those groups celebrate, that we accommodate them for that. And we do make sure that that minorities and women are included on different teams. Frankly, for White & Case, it hasn't been that big a problem as in other firms, because we work across diverse countries, and so our clients have for a long time expected and demanded that our attorneys reflect the makeup of their clients, and our clients are in Abu Dhabi and in Beijing and in Tokyo and in Berlin and Paris, and so we've always tried to hire people that are and have partners that are leaders in those different communities. And then, of course, we get together. So as an international firm, we're accustomed to working that way. I think where we have to keep making strides is in the number of Black lawyers and Black partners in our firm. We have them, but I still think that we need to focus on that more. And part of it is making sure that that those minority groups are going up the educational ranks and getting into law school and wanting to become lawyers, so that the market is out there for us to get them. So I think as far as inclusion, the most important thing is when you hire somebody, diverse attorneys, that you make sure that they're included in, the big projects like other people are, and they're part of the team. That's the saying that you always hear is, diversity is being invited to the party, inclusion is being asked to dance. So it's not enough that we just hire these people. We have to give them the opportunity to grow within the firms. And sometimes it means informal leadership, mentoring. Sometimes it means more formal mentoring. Make sure that they have all the skills, and not just legal skills, but leadership skills to move up the ranks. Sometimes people are missing one skill or the other, and you want to make sure that they're well trained, so that they have that opportunity 6, 7, 10 years down the road to become a leader at the firm.
So speaking of, learning those skills, so we do have a question. We have two questions in the chat. The first one is from Alex Jimenez, who's one of our Young Professional Council members. And he wanted to ask, what are some suggestions that you can give us, you can provide to attorneys, associates, about how we can improve our, I guess, appellate kind of skills when it comes to oral argument and writing briefs. Maybe it's hard for some associates to get those kind of skills. So what can you recommend, in terms of improving those skills?
Well, I always tell young lawyers never to rely on only on-the-job training to keep learning. When I was doing appeals back in my prior firm that I told you about, I didn't have anybody teaching me how to do appeals there. There was no partner standing over me saying, this is how you do it. I had to learn it all myself. And so I got every book I could find on appellate practice, on legal writing, on appellate writing, on oral argument, from the best lawyers and judges who had written books on the subject. And I just read, one book after another after another. And the great thing about doing that as you're working is you get to put that into practice more quickly. And then you retain that learning and that information a lot more than you do when you're in law school, for example, and you take an antitrust course, and then you never look at another antitrust issue again, and then 20 years later they ask you about an antitrust issue. I don't remember, I just took one class in it. Because even though you spent 4 months studying antitrust law, you never put it into practice, and so you forgot everything you learned. But since you're now in the working environment, and lawyers are writing all the time, if you're reading about writing and you're implementing it the next morning, you're going to retain that a lot more. And even now, at my age and with my experience, I'm rereading some books on appellate practice and appellate writing because, I feel I still have something to learn. I don't think I've reached, the pinnacle of where I can be as an attorney. There's always higher up that I can go. I can get better. My quality can get better. And so I read and reread and listen to lawyers and judges talk about appellate practice and writing. So my advice is never stop learning, never stop learning. And if you find lawyers that are good in their field, go to them and ask them questions and get all the information you can from them and learn from the best.
It's great advice. We should definitely all take that and keep learning. We had another question in the chat from Karen Cespedes. She's actually another member of our Young Professionals Council and the former chair. So Karen, thanks for being here tonight. She wanted to know, what's the biggest factor that's helped you become successful, and how has the definition of success changed for you from the beginning of your career to where you are today?
Well, I think the definition of success is being the best you, whatever you're doing. And I think that under that definition, you can be a police officer, but you can be a successful police officer, a successful teacher, a successful engineer. I don't think to be successful means that you're making a lot of money. It just means you're the best at what you do. And so I think that if you try to be the best and keep learning, at the end of your career, if you have the blessing to be known as the premier whatever in your field, then you're successful, and you've reached that level. But you shouldn't expect to reach it without a lot of work, and probably more work than most people are willing to put in, because a lot of lawyers are average lawyers. Then there's some that are very good lawyers, and then there's some that are great lawyers. And what divides them is not as much that one is smarter than the other. If you read books like Malcolm Gladwell's book Outliers, or Grit, a book by Angela Duckworth, or some other books on leadership and success, it's been shown that the most successful people are not successful because their intelligence is so high. After a certain level of intelligence, it all depends on your work ethic and how hard you're willing to work to get there. and your grit, your perseverance in getting there. And so I think in reaching success, if you do some of the things that we've been talking about, you're going to be a successful lawyer. So how has success changed? How has my definition changed over the years? I don't think it's really changed that much, in the sense that, I think a successful lawyer is somebody who can look himself in the mirror and be proud of himself or herself, because they've had a good career and they've kept their integrity no matter what. I think that's the most important thing, is to keep your integrity. And sometimes, if you have to, sometimes integrity means you have to make tough choices, decisions, and they may affect you financially, or they may affect your relationships. You may lose a client. But if you take that step, I think years later, you're going to forget about the client. You'll remember the action that you took. I have another story I tell, which is when I was a practicing attorney back before I became a justice, I was representing a very well-known, kind of famous client in a case in federal court, and the other side wanted to take discovery and find some compromising materials. So, we contested it in court, and the court said, well, we want you to look for it, and we'll figure out later if it's admissible, but if you find it, it's discoverable. And so we went through the process and we looked for it, and I had to report to my client that we did find some compromising information in there. And so I went to the client, and I'm a young partner at the firm in my early 30s, and this is a very wealthy, well-known individual, and I'm telling this person, this is what we found, and this person told me, well, look, maybe we can just tell them we didn't find it, and go from there, and I said instinctively, no, we can't do that. We're going to have to tell them, and we're going to have to deal with it, and we will. And he didn't mention anything after that. And on the way home, I kind of said, I can't believe I said that. I can't believe I did it. But I always tell people, do the right thing quickly before you have time to do the wrong thing. And so that's why I kind of blurted it out of my mouth. I knew it was the right thing. And I knew, man, if I think too much about it, maybe I'll be tempted not to do the right thing. And so, I think if you have a foundation of integrity and morals, and you live by that, and you know that you're going to survive no matter the consequences, then it makes the decision making down the line a lot easier than if you don't have that foundation and you think that there's a choice to be made every time there's a moral decision.
That's great advice. Do the right thing before you can think too long and do the wrong thing.
I think Bob had something to say. Bob, did you have you were raising your hand, I think.
On mute. I was going to ask it, but you started answering it with your last answer. I want to ask you a very personal and sensitive question, which would be of great benefit to everyone listening. You have been a member of various groups, and I have known through the community about you on occasion disagreeing with the group. You were appointed by a wonderful Republican governor, and you have on some occasions taken positions that weren't Republican. And you've done that in a bunch of other things, and I can personally picture you being at a firm meeting here in Miami, or even with the senior people in New York, and saying to them, I disagree. I don't think we should do that. As a matter of fact, I'm not going to do it. And I want to know what it takes. And I know the easy answer is your upbringing, Judge Davis, but what it takes to have the guts and the stature to be able to stand up and dissent without being considered a troublemaker, a a rabble-rouser, someone who's just difficult. What does it take to develop a reputation that people know when we speak to Justice Cantero, we'll get the right answer? Not the Republican answer, not the white and case answer, not the legal services answer. We'll get what he thinks. What does it take to develop that independence so that you sleep so well at night?
Wow, Bob, that's a tough question. I think there are a lot of factors involved in that answer, a lot of factors. I think I can't answer that question without talking about my Catholic faith, because that, governs everything that I do. And, if you really truly believe in that, then there's certain things that you just have to do. And then you have faith that the consequences aren't going to matter, that you're going to be okay no matter what happens. And if that costs you a job or some appointment here or there or a reputation in some circles, then everything's going to be fine. It doesn't matter, because you did the right thing. I think also it takes a lot of listening, because I don't just talk, I do a lot of listening, and I try to understand what other people are saying and what they're thinking. And so, and I think that's something that's missing in a lot of public discourse. Is there's a lot of talking, but there's not a lot of listening and not a lot of seeking understanding of the other person. And I always try to seek to understand what the other person's saying and why they're saying it, and kind of digest it, and then respond in a non-emotional way to that particular concern and address that concern. And if I disagree with it, have a cogent answer and a logical answer about why I disagree and I can't go in the direction that they want to go. And I think at least if they don't agree with what I said, they understand what I said and they understand why I have to take that position. And I think that goes a long way toward maintaining or developing good relationship, even where you disagree.
Definitely. Thanks so much for that answer. Thanks for that question. Appreciate it. I think we have time. We have a few items we want to close out with, but I think we have time for another question. If anyone has anything, they can unmute themselves or write it in the chat. I can read it out loud. If not, then I have another question that I could ask. I don't know if you guys want to still hear from me anymore. Mine will be quick. I guess I just wanted to know about, I think we're all curious, any of the more interesting, or I guess we'll leave it at interesting cases that you heard while you were on the bench, the Florida Supreme Court. What are the memorable cases that you kind of still make you scratch your head today when you think about them?
Well, probably the most memorable case I had was the Terry Schiavo case. And to Bob's point earlier, that's a case that was very controversial. Many of you may not recall it because this is back in 2005, so I don't even know how old some of the people on this call was. Please don't tell me, I don't want to know. But what happened was Terry Schiavo, I don't remember how, but somehow she fell into a coma, and her husband said that she had wanted to be have the plug pulled, essentially, if she fell into a coma. By this time, she had been there for 6 months or more. She had been in a coma, and that she had expressed a desire not to live that way. Her parents, on the other hand, said no. She expressed a desire. She did not want to be taken off. She didn't care. She wanted to keep on living. Well, the judge held a hearing and held in favor of the husband, saying, I believe what the husband says, and that she would desire not to be this way. It went up to the Court of Appeal. The Court of Appeal affirmed, saying, we're not going to substitute our judgment for the trial judge's judgment. Those were credibility decisions the judge had to make. So after that, it became a very controversial case in Florida. And it was so controversial that the Florida legislature enacted a law that would have required her in particular to be kept alive. And it was written in a way that applied only to her case. And that went to the Florida Supreme Court, and it was very, very well publicized. I remember, I think it was over Easter vacation where we were coming out with an opinion, and we decided unanimously that the legislature had no authority to do that, that they can't change ex post facto a judicial determination, that it violated the separation of powers in the Florida Constitution. Well, it was a very controversial opinion, and I remember we happened to be in Miami after the opinion came out, maybe because, you know, it came out over Easter, and I was sitting in the third pew at Mass when the priest that Sunday railed against the Florida Supreme Court's decision in the Terry Schiavo case. And, you know, I kind of slunk in my chair like this, you know, but that is kind of burned in my memory, that case, because of all the publicity surrounding it. But what I'm proud of in that case was that we had it was probably it was a court that was mostly 4-3 in that era. I was one of 3 usual not usual, but occasional dissenters. But we were unanimous in that opinion, and we all agreed this violated separation of powers. So, you know, I was very proud of the court in that instance, and how we stood up for the Florida Constitution. You know, I'm one that doesn't think that everything's unconstitutional, nor should we declare something unconstitutional because we don't like it. But when it's unconstitutional, we need to call it out as such, and that's an instance where we did that. So that was probably one of the most memorable cases. Another case that was memorable was a case called Ballard versus State. It was a death penalty case, and it came to us, and the only evidence pointing to the defendant as the perpetrator of the murder was a fingerprint in the victim's bedroom, underneath the bed of the victim. Just one fingerprint, no fingerprints on the murder weapon, and also his car was discovered within a mile radius of the victim's house. Well, the defendant said, yeah, the victim was a drug dealer, and I bought drugs there, no question. I admit that I bought drugs, but, you know, I didn't kill him. Well, that was a case I remember where we reversed not only the death penalty, but the conviction itself, because the evidence was just too slim to convict somebody of murder under those circumstances. And again, that too was a unanimous opinion. And I was very proud of the court in that case as well. And that's the only case, I think, where we reversed the conviction. We reversed the death penalty several times, but that's the only case I remember where we actually reversed the conviction. So that kind of sticks out in my mind as well.
Well, those are definitely 2 memorable cases, so I can see why you're still thinking about them after all these years. And I think, for the record, you know, we're young professionals, but I don't think we're that young. I think all of us remember the Terry Schiavo case. I won't speak on behalf of everyone, but I'm pretty sure that we're old enough. So thank you so much, Your Honor. It's been really an amazing night tonight. We really can't thank you enough for taking time out of your very busy schedule with everything that you have going on to speak with us. I can speak on behalf of everyone here that we've all really learned a lot and really appreciate all of your insight. You know, it really means a lot to us to know that, you know, you're really committed to the organization that a lot of us commit a lot of our time and energy to, and to see why, you know, it's so meaningful to you and how it fits into your career, and just to get the insight from you on, you know, all of your experience practicing law for all this time. So really, thank you so much. Before we leave, I wanted to give 2 plugs for legal services. One is for Give Miami Day. We have that coming up. Everyone should have it on their calendars. It's next Thursday, November 19th. The Young Professionals Council does have its own champion page if you're interested in donating and helping us try and reach our goal. It's going to be www.givemiamiday.org/YoProCouncil. And then for those of you, I'm sure most people here are familiar with Give Miami Day, but for those of you who aren't, there's a minimum contribution of just $25, and a portion of your gift will be matched by the Miami Foundation. So if you're thinking about giving that day, or giving to legal services, then that's a really great day to do it, because there are additional funds that will become available. So please consider legal services on that day. And then also, thanks to one of our newest members, Jessie Science, we're hosting, and Jamie Cassidy on behalf of all her efforts as pro bono. The Young Professionals Council is partnering with the Miami-Dade chapter of FAL, the Florida Association of Women Lawyers, for an eviction defense webinar on Monday, November 23rd. That'll be in the evening. So please be on the lookout for an email to sign up. I'll try and make sure that I capture everyone on this group. If you're not already captured by the other, legal services listservs. But, those are two great events and activities that we have coming up, and we hope that as many of you are willing and able can participate. And I just want to say thank you for everyone for joining us tonight, especially our leader. I mean, how could we start with anyone else with everything that you've done in your career, Your Honor? So it's really been a pleasure and an honor to have you here. Thanks again. And I guess good night, everyone. Stay safe, and hope to see you all soon.
It's my honor, and thank you very much, Legal Services, for all the work that you all are doing. I see that Jeff Hearn is here, and I know all the work he does in the landlord-tenant space.
Mm-hmm.
And he's a great leader there. So thank you, Jeff and Monica and everybody else at Legal Services for all the work you do. You're the unsung heroes. You really are.
Well, thank you for taking the time. It's really nice, and all the craziness that's going on, to take an hour and to think about things like integrity and values, and sort of really raising the bar on what it means for access to justice and the impact it has on our community. So thank you for speaking to us, and thank you, Jenny, for taking the time to lead the conversation with him. So I hope you all have a great evening. Thank you. Thank you, everyone.